Well, good morning. Hi, I'm Greg Monteverdi, Assistant Assessor. Welcome to the Assessor's first informational meeting on potential possessory interest assessments of parklets intended for jurisdictions that are stakeholders in their assessment and co-beneficiaries of any resultant property taxes. Today, Lawrence Stone, Assessor, will make introductory remarks about the evolution of these new potential assessments, his obligation to evaluate them as being taxable or not, and then introduce John Recchio, Chief Appraiser of the Real Property Division, who will address all of these issues in greater detail. You will be muted in this webinar and chat will be disabled, but we do encourage you to pose questions in the Q&A and we will attempt to address them as they arise. If they require a lengthier or more thoughtful response that can be addressed in the Q&A, we will get back to you. The presentation will be recorded and published on our website by early next week. Thank you for your participation in this webinar. We are at the exploratory stage of the potential assessment of parklets, and the dialogue begun at this meeting will be crucial in determining our next steps. Now the assessor will explain why we've come to see parklets as an emerging issue that must be addressed together consistently through our county.
Well, good morning. COVID state and county health orders required most commercial and public enterprises to shut down. Restaurants were particularly impacted. Many cities and public agencies allowed restaurants to extend their operations outside into the public streets and sidewalks. The intent was survival in the face of serious medical crises. Parklets, as they became known, were very popular even after the public health order was lifted and indoor service to the public resumed. In one case, a restaurant I patronized nearly doubled its table space. Many cities have made or plan to make these parklets permanent, sometimes reconfiguring streetscapes, including structures and canopies and enclosures to accommodate the businesses and their patrons. In essence, it appears that these private entities are being conferred with permanent rights and benefits of public property. It is at this point where the California Revenue and Taxation Code comes into play and obligates me as the assessor to review the rights and benefits granted and decide whether they create a taxable possessory interest. Whenever a commercial enterprise occupies a public facility, which includes public streets and sidewalks, a provision in the Revenue and Taxation Code called possessory interest comes into play, which is a claim or right of possession of public property by a commercial enterprise, which may trigger a taxable activity. As a citizen and taxpayer, I would hope and indeed expect that my city would treat parklet transactions like a normal business transaction, as the PI, if established, will be treated as a normal business transaction. Examples include the San Jose Sharks, who occupy the SAP Center, or the 49ers who lease the Levi Stadium from the city of Santa Clara. A lesser example would be the Starbucks or other vendors that you visit at the airport. In all such cases, the assessor renders a PI assessment. Chief Appraiser John Recchio will now explain the legal tests that establish a possessory interest, the documentation required to calculate the assessment, public reporting requirements, timing of assessments, and the low value ordinance that we have in Santa Clara County. John?
Thank you, Larry. As you can see, my video is a little strange looking. I have this weird sun effect on me right now, but that will go away shortly. Thank you very much for joining us today. As Larry mentioned, my name is John Recchio. I am the Division Chief for the Real Property Division with the Assessor's Office. Today, I'll be going through some possessory interest factors that relate to parklets and promenade spaces that are being considered in the various cities in our jurisdiction. So the short agenda here will give you an idea of what I'll be going through. It will touch on everything from, what is a parklet and a promenade space, how are we going to value them, why does a PI get created, and how they're going to be assessed going forward. So what is a parklet? Well, a parklet, basically, as probably all know when you see them, is a seating area constructed in one or more public on-street parking spaces. As Larry mentioned, these were started in response to the COVID emergency, and they've continued in many places, and that we've seen them become more permanent in some jurisdictions already. Other jurisdictions are actually closing streets and creating public promenades. Seating areas in these spaces may also be subject to possessory interest assessments. We've seen this happen on Castro Street and on San Pedro Square in San Jose. So what is a possessory interest? Well, basically, as Larry mentioned, it's a private use of government land. In this particular case, the example that's shown here is we do have some cattle ranchers that use public land in our county, and they're issued a PI for the use of that land. Larry mentioned the San Jose Sharks and the 49ers. Those are very large PI holders, but we also have very small ones. We have the attendees, the booths that set up at convention centers are issued PIs. We have airplane hangars that are rented at the various airports in the county that are issued PIs. So this is a broad thing that we assess based on that private use of public property. I wanted to include some legal authority here for you to take a look at and the creation of the PIs and why it's important. So Section 1 of Article 13 of the Constitution spells it out. That's our taxing jurisdiction. And I wanted to include this section in particular because this will affect how you, the different agencies, interact with the people that you allow to use these public spaces. This is a notification responsibility on your part to those that you give this right to. Basically, this states that you are required to let the person or the entity know that they may be billed as a possessory interest and have property tax due. So I figured this would be important for all of you to understand going forward. So any of the leases or permits that you issue or licenses that you issue, you would have to cover this as part of that. Now, failure to do this notification creates the right for the possessory interest holder to actually come back against the city or issuing jurisdiction for damages. Now, they don't have to prove anything other than they weren't giving notice of the possibility of possessory interest taxes. So it's very important that this notification of possessory interest is included in any of the documentation that you sign with the property user. So parklet size and use of public areas. So we've seen parklets, ranging from 2 to 5 parking spaces, and it's basically the width of the establishment that's going to be using them. The sidewalks, typically, they're shared by everyone, so those aren't part of what would be assessed, but the parking spots and the use of promenade space that is being created may create taxable possessory interests. The sidewalk, people are going through it all the time. That's not going to be considered as part of the valuation of what the possessory interest is. Now, promenade possessory interests do change the parameters just a little bit. The location, use, and size of the promenade space will need to be defined in each of your licenses, permits, or lease, however your jurisdiction decides to create these uses. And the use of these spaces must have some sort of exclusivity. Sorry about that. Basically, what that means is a particular restaurant or business will have the use of space in the promenade. Exclusivity does not mean that it's exclusive of everyone else using that space. It just means that they are of a limited number of entities that can use the space for their business purpose. So in the case of the picture that's on the screen now, you will see some chairs and tables out in the promenade space. That area is exclusive. It doesn't mean that people can't walk through it. It just means that that entity that is using that space has the right to use that space. There have been questions about what comes up if, the PI is in a promenade and the city decides to hold other events in that promenade, say a weekend farmer's market or some other band playing or some other type of entertainment, that does not decrease the actual value of the promenade space for the restaurant or the other business entity that's using it. Shared use is allowed under possessory interest rules. So this is a small example of what we've seen in the marketplace. Rents and fees that range from $2 per square foot to $5 per square foot. The city of Palo Alto recently was doing parklets, that cost about $9,125 annually. Larger parklets would go up from there. That information came from the Palo Alto Weekly earlier, 2022. The fees and rent is mostly licensing fees and permitting fees from what we've seen. And most terms are annual, so it gives them the right to use it on an annual basis with renewals happening every year. That's just what we've seen so far. What each of you decides to do with your jurisdiction will depend upon what you deem responsible for you. And then we'll take a look at that and see how that fits into the possessory interest valuation. So in order to qualify as a possessory interest, the interest must be durable, there must be some sort of exclusivity, and there must be a private benefit. So what does durable mean? Well, durable means that we have to show that the area is being used on a consistent basis. So if there's a contract, a lease, or a license that says you can use this for a particular year, that starts the durability. Typically, what we see for the type of instances with permits and licensing is that we don't assess the first year because we can't prove that they're going to be there for a long period of time. What starts is the second year assessment, and we see that as establishing the durability. This wasn't a one-time event. They're going to be there for a prolonged period. And then we would assess them based on a 2-year anticipated term. That means that whatever value we determine that area to be, we would base it on a 2-year term of that use. That will change during time as the establishment of these parklets becomes more permanent, use of the promenade space becomes more permanent. As we see agencies issue those annual licenses or permits and the individual users staying 4, 5, 6 years, that durability may increase to 3 or 4 or 5 years, depending on what the market conditions say is a reasonable term of possession for that area. And again, as I mentioned, for exclusivity, you do not have to have the right to exclude everyone. Basically, your exclusivity means that you do have the right to use that public space, and that public space is being used for your business. And there must be a private benefit. I think that's pretty self-explanatory. A public entity is not using it. There's going to be a private benefit for the person or the entity that has that license. So assessing a possessory interest. Fees or rent are only a single data point in determining an assessable value. We always have to base our assessments on market value of the space being used. So we will take the fees and the rent into consideration, but as I mentioned, that's only a single data point. Market value indicators can include commercial land value, retail lease rates, again, the license fees and rents, and possibly others. We don't know exactly how yet these are going to be valued because we haven't seen them actually come through the cities as licensed and paying a fee and being of durability enough to initiate that assessment. So the market value indicators are going to be very important for us moving forward. One thing to keep in mind is that the market value of the lease rates, if a building owner had that space and was using it as part of the lease for the restaurant or other business that was in there, would they charge a higher amount for leasing that space if it included the space that you're going to be licensing in the public promenade or in the parklet? So that's kind of where we come from when we talk about market value indicators. So Santa Clara County does have a low value ordinance. So what that means for the PI interests is that that low value ordinance has been set at $10,000 of assessable value. Well, that means that if we determine an assessable value for a parklet or a promenade space below $10,000, then that possessor is not issued a tax bill. That doesn't mean we haven't assessed them. It just means that they're exempt from the property tax bill. We still have to establish the value and then exempt it from taxation. So keep that in mind as well as you're looking at these. The economic impact to the building owner or the restaurant owner is going to be dependent on whether or not that $10,000 assessable value is reached. So a few questions that came up when we were signing people up for this seminar was, what happens when these assessments are issued? Well, one of the things I wanted to make sure everyone is comfortable with is that no existing Prop 13 values are affected if a property owner or business owner obtains a PI assessment. The PI assessment is separate and distinct from currently existing Prop 13 values for real property. So if a property owner wanted to get one of these leases for a parklet or promenade space and hold it year after year and use it as a way to increase the value of the leased space that they have, it would be a separate and distinct assessment from their building. So who gets the assessment? Well, that depends on who obtains the rights to participate in the parklet or promenade space. Is it the business that is getting that, or is it the property owner that is obtaining it? We would assess whomever that right is vested in according to the city contracts. So how to report the permits, licenses, leases, etc., and when to report that information. We currently send out annually in December or early January each year, possessory interest reports. There's two examples of them up on the screen currently. The one on the left is the state form that we send out to every agency that we're aware of that is issuing public use of private use of public property. The form on the right is a property usage report that we send out accompanying it. It's a different format that will allow a little quicker use of reporting. We send this report out annually. If the person that we have as a contact is moved to a different area in the city and the new person taking over doesn't have the history, we can actually send them the previous year's usage report so they understand what last year's report looked like, and they can report any changes to us. So this goes out at either the end of the year in December or the beginning of the year in January. And it can be returned electronically as well. So parklet promenade structures. A lot of questions came up about how these will be assessed and how these are handled. A lot of it comes to who is building the structure. Is the city or jurisdiction doing the structure work, or is the business or the property owner doing the structure work? And where is it being built is a lot of that as well. Is it being built on the public land, or is it being built as part of their current ownership? Is the structure permanent or removable? Most of the structures we've seen in parklets have been movable or removable. They haven't been permanent structures. They may look fairly permanent in the way they're built, but they're designed to be able to be removed without damage or too much damage to the street. Those would be non-permanent structures. And then we would also need to know what department is issuing the permits and licenses. That will help us in communications with your different jurisdictions in determining how many of these exist, where they are, how they're being built, and then how they will be assessed afterwards. One of the things that is always under question is, what is the business division going to be picking up? So this goes along with the previous slide in the structures, in that if the business or building owner that has the license or the permit to use the space is building the structures, most likely it's going to be non-permanent and it will be part of the business division's responsibility to pick it up. The real property division is really concerned with doing the land assessment as a possessory interest. So how will the business division be picking these up? Well, it'll be the business's responsibility to report the information on the 571L reporting that they have to do annually. Most likely this will take the form of additional chairs and tables and maybe heating lamps and umbrellas and any structure that they are responsible for when the parklet or the area of the promenade is being used. And that pretty much concludes our presentation for the parklets and promenade PI space. Again, if you have questions, please put them into the Q&A and we will get back to you as soon as we can on those. This is a reminder slide that our office is moving to a new location at the end of this month. We'll be up and operational on August 28th, 2023 at our new address at 130 Tasman Drive. All the phone numbers and all the other contact information remain the same, so you don't have to worry about that. So thank you very much. And that concludes the presentation.
Okay, so this is Greg Monteverdi again. And I've been attempting to keep up with some of the questions in the thread. One of them that I was just drafting my response to was essentially a request to address further one of the tests of possessory interest assessment, and that is independence. And it was raised by one of our colleagues in San Mateo County, Preet Sikon, who did correctly cite the Assessor's Handbook addressing independence, and it talks about the fact that the possessor must have the right and ability to exercise significant authority and control over the management or operation of the real property, separate and apart from the policies, statutes, ordinances, rules, and regulations of the public owner of the property. So it's not enough to have mere agency. It's required to have this level of independence that is defined within the California Revenue and Taxation Code, as well as in the Assessor's Handbook. I think it's 510. And let's see if there are any other open questions. I don't believe there are. So thank you for your time. If you need more explanation or clarification of this topic, or feel as if further meetings addressing it would be helpful, please contact Deputy Assessor Autumn Young, who is serving to coordinate our community outreach on parklets. Her email address is autumn.young@assccgov.org, and her phone number is 408-299-5572. Thank you all for your time.